Grüß Gott in der bayerischen Vertretung. Meine Damen und Herren, es ist schön, so einen gut gefüllten Saal vor sich zu haben. Hier sind noch Plätze, sozusagen fast in der ersten Reihe. Wenn Sie ein Headset brauchen für die Verdolmetschung, haben wir da auch noch was für Sie vorbereitet. So viel zum Housekeeping. Sehr geehrte Datenschutzexperten, namentlich darf ich die heutigen Co-Veranstalter begrüßen, nämlich den Bundesbeauftragten für den Datenschutz, Herrn Ulrich Kelber, dann per Video zugeschaltet den europäischen Datenschutzbeauftragten, Herrn Giovanni Buttarelli. Sehr schön. Dann haben wir die Vorsitzende des Europäischen Datenschutzausschusses, wäre geplant gewesen, die Frau Jelinek, die heute leider wegen einer EuGH-Sache verhindert ist, aber wir freuen uns, dass Frau Liz Denham bei uns ist. Sie ist die Datenschutzbeauftragte des Vereinigten Königreichs und Vorsitzende des Exekutivkomitees der Internationalen Konferenz der Datenschutzbeauftragten. Sehr geehrte Vertreter der Europäischen Kommission, namentlich darf ich ganz herzlich begrüßen Herrn Dr. Selmayr, sehr geehrter Herr Präsident des Bundeskartellamts, Herr Mund, liebe Vertreter der Medien und ein ganz herzliches Grüß Gott an unsere Moderatorin, an Frau Stupp. Ja, verehrte Mitglieder des Europäischen Parlaments, meine Damen und Herren, es ist schön, dass Sie zu diesem aktuellen Thema, ja, Datenschutz im digitalen Zeitalter, zu uns gekommen sind. Wie Sie wissen, wird in Deutschland Datenschutz großgeschrieben. 1970 verabschiedete Hessen, nicht Bayern, es war Hessen, aber es ist in Ordnung, das weltweit erste Datenschutzgesetz. Das Bundesverfassungsgericht hat im Jahr 1983 das sogenannte Volkszählungsurteil erlassen, in dem das Recht auf informationelle Selbstbestimmung als Grundrecht seinen Eingang gefunden hat. Europa, um den Blick in die Gegenwart zu werfen, hat mit der Europäischen Datenschutzgrundverordnung nun einen Standard gesetzt, insbesondere auch in großen Nationen wie Japan, Brasilien, Indien und selbst in den USA gibt es Überlegungen nachzuziehen. Die frühere Justizkommissarin Reding nannte das sogar den Goldstandard einer vernetzten Welt. Die Datenschutzgrundverordnung hat die Wahrnehmung von Datenschutz jedenfalls in Deutschland und auch in anderen EU-Staaten sehr grundlegend verändert. Das ist sehr positiv. Es ist ein rechtspolitischer Erfolg, ein einheitliches Datenschutzrecht in Europa zu haben, einen einheitlichen Rechtsrahmen, der gerade für exportstarke Unternehmen wie in Bayern oder generell in Deutschland sehr nützlich ist. Allerdings gibt es vielleicht den ein oder anderen Punkt in der Alltagstauglichkeit, wo man noch mal etwas hinsehen müsste. Es gab in Deutschland Diskussionen um Datenschutz bei Klingelschildern an Wohnhäusern. Jeder von uns war mit unzähligen Einwilligungsmails und umfangreichen Formularen bei Ärzten, Banken und Versicherungen konfrontiert. Ein gewisser Datenschutzbürokratismus hat sich da schon gezeigt. Im Schulterschluss mit den für die Unternehmen und auch für die kleinen Vereine zuständigen Bayerischen Landesamt für Datenschutzaufsicht hat die bayerische Staatsregierung deswegen versucht, durch massive Aufklärungsarbeit, durch viele Gesprächsrunden einen vernünftigen Weg zur Anwendung der Datenschutzgrundverordnung zu finden. Nach dem Grundsatz der Verhältnismäßigkeit oder wie man das in Bayern auch gerne sagt, einfach die Kirche beim Dorf lassen. Daten sind zu einer Währung geworden. Jeder, der soziale Medien nutzt, jeder, der bei Online-Händlern unterwegs ist, der Informationsangebote nutzt, weiß das. Daten haben einen Wert und Wertvolles schützt man. Ich freue mich mit Ihnen zusammen auf einen interessanten Abend, auf viele Anregungen und genießen Sie ein bisschen auch die bayerische Gastlichkeit. Ich danke Ihnen ganz herzlich.
Well, ladies and gentlemen, you can take off your headphones. I'm going to speak in English. As Mr. Kelber has just put it, if 5 Germans are together in Brussels, they're going to start to speak in English. So we're at least 5 Germans here, so I'm going to speak in English. Well, I think it's my task today to bring competition law a bit closer to you and to speak a little bit about how is the link between competition law and consumer protection law and data protection law, privacy. Having said this, I'm really honored to be here with you tonight, Mrs. Schretter, Mr. Kelber, Mr. Buttarelli. I'm really honored to be here tonight. And it is very exciting for me because this is really not my home turf today. I know how much you know about data protection law, well, I'm a bit humble to be here and to speak about the matters I want to bring close to you. I will try to explain the Facebook case a little bit that we have been dealing with and try to show up the connection between competition law on the one side and why data protection law has become so important also for us as pure competition people, especially in the Facebook case. There have been many lawyers, especially from the competition side, who said, well, Andreas, tell me, what are you dealing with there? I mean, this is privacy, this is data protection law, and you are competition lawyers, so tell me, what are you dealing with? And I try to explain that a little bit today. Well, the title of my speech is already Data Protection and Competitiveness in the Digital Age. And you see already from this that there is this close link between competition on the one side and data on the other side. So there must be a link between competition law on the one side and data protection law on the other side. And this must be all the more true if we look at these huge companies. Many of us think of GAFA when we talk about this topic. GAFA, Google, Apple, Facebook, and Amazon, as we say it in the competition world. I don't know if this is familiar to you as well. But you should always add BAT in your head. BAT is the Chinese competitor, which stands for Baidu, Alibaba, and Tencent, who are about to set a foot into Europe and who, from my perspective, might create exactly the same problems as GAFA is creating today. So these global services are part of our everyday lives, social networks, search engines, digital assistants like Alexa and others. And of course, personal data plays the key role in these services. At first glance, all these services for the consumer are for free. In reality, it happens that the consumer is giving away his or her data in return for making use of these services. And the business models that we are looking at here, you should always have this in mind. These are business models which are purely data driven. There's nothing else behind it. The business model is purely data driven. So in the very end, it's all about the collection of data and how it is processed from as many sources as possible. I will come back to this later. So you cannot talk about the pitfalls before you talk about the advantages this all has, because it has huge advantages. We see a lot of data-driven innovation. We see algorithms, we see artificial intelligence that brings a lot of benefit to the consumer. We see new services, data-driven, but new services, very popular services, by the way. The consumer loves all these providers. You should never forget that, always have that in mind. So there are, in fact, huge benefits. But, of course, there are also pitfalls. And the pitfall, from my perspective, is the huge volume of data that is collected. Just think of Google. Google knows the personal search history of Andreas Mund since 20 years. My personal search history, which should have provided a lot of data. The moment we are sitting in this room, Google is gathering new data about me, lots of data. And this data has one huge advantage. It is very reliable because it's my data. It's the data that I hand over personally. They can make use of it in real time. In real time. Plus, they make use of data of which I even don't know that it is handed over. There has been a study in the United States, I think it was from Pittsburgh University, which says that any Android phone connects with Google 40 times per hour without that the consumer even knows about it. Google says this is not true, but they have never ever published the real number, and maybe there is a number. Another experience that we have made in our Facebook case is how the data is used. I mean, that has been most interesting. You see a wall there, and on the top of the wall there's your name, Andreas Mund. And underneath that name there are 10 clusters, which are, well, it sounds banal at the first moment. It's my age, it's if I'm married, and all these kind of issues. And each of these clusters has another 10 clusters, and each of these 10 clusters has another 10 clusters. And when you see that wall in the very end, which is you, I began to understand what Tim Cook, the CEO of Apple, meant when he said that Facebook was taking measure of the consumers by military profiling. So this is what it must look like. So it is the amount of data, the use of data that is not only worrying you from the perspective of data protection, that is also worrying us as competition people from the perspective, who shall compete with these companies? Who shall ever again compete with companies like Google and Facebook, having this trove of data which is not shared with anybody else? That is also a competition issue, clearly, because no other company has this kind of data. So necessarily, if I make use of another search machine than Google, it knows less about me. It has less data of Andreas Mund. So necessarily, this algorithm of the other search engine is worse. It's necessarily like this because they do not have all the data. So another company that wants to come in finds severe difficulties in competing with other companies, and competing has a lot to do with competition and competition law and new entrants in the markets. Newcomers that want to contest these markets will be very hard to find. In the end, it's the consumer who pays the price, because in the very end, it's the consumer who gives away data limitless to a monopoly or to a duopoly. The consumer has no choice in the very end on which provider he wants to use. And in the very end, the consumer is also confronted with a lack of innovation, a bitter consequence of a monopoly. We have seen that before. I don't know if you remember, well, most of you will remember the early 2000s, when Microsoft had been very successful in kicking out all the competitors with regard to internet browsers. The only internet browsers after Netscape had left the market was the Internet Explorer. So in the early 2000s, does any one of you know how many updates the Internet Explorer got in the early 2000s during 5 years? None, exactly none. And it took the Mozilla Firefox to make all of us sit in front of a screen and say, oh, what an innovation. There's a second browser window. Wow. That happens if you have no competition in the digital world. I mean, one of the most innovative industries that there is out there, no innovation for 5 years. Another very typical effect that we see in the digital economy are network effects. That has not so much to do with data protection, but that is the second reason why these companies get so big. Network effects typically arrive on these platforms. Facebook is an example, an excellent example, by the way. Many users on the platform are attracting other users, and these users again are attracting new users because, of course, everyone wants to be on the same platform in order to meet friends and in order to meet interesting people. There are also indirect network effects. You see those on Amazon. Users attract providers, providers attract new users attract new providers. So in the very end, it is a little bit like a snowball system. So data plus these network effects are the key drivers for the fact that these companies are so enormously big. Network effects are difficult to tackle with competition law because they are a result of economic efficiency in the very end. And it's very hard to find a pattern to deal with network effects from the perspective of competition people. So what we do in order to tackle the dominance of these kind of companies, we tackle data. The second effect, why these companies are able to get to such a growth. If data is a key factor for market power and even for dominance, I think we need to look for options how to deal with data. And from my personal perspective, there are three options how to deal with data if you want to break market power of a company. The first option is to ensure portability. That is a key option if the consumer can take his data to another provider. That is laid down in Article 20 of the GDPR. I always have the feeling that is still in its early beginning. That doesn't happen too frequently yet, but we might see some development here. A second possibility to deal with data, and I think this is the future, that is to enforce access to data. That is the key question, if we can do that, and if we can do that successfully, and how to enforce that. Will it be possible and necessary that these huge companies I was talking about, Facebook, Google and others, open their data trove to others in order to make others able to compete with them? That is also an important discussion in the context of Industry 4.0, the communication among machines. Here we have similar problems. I say this is the future, but I think it is. We have the means as competition agencies today to grant access to this kind of data. There haven't been many cases yet in this respect, and of course, we face here very difficult questions with regard to GDPR, because we are talking about personal data. So we might talk about the fact, do we have to grant access to personal data under the rules of GDPR? You can easily see this is a very complex question that we have to resolve here, and this might be why you haven't seen so many cases yet. But I personally believe the data is necessary in order to compete on these markets. I had that discussion from time to time with Hal Varian, the chief economist of Google, and he always said, Andreas, if you ask me, shall I have to give to you all the data that Google has, or all our engineers that we have who can work with that data? He always said, well, I give you the data, because that is duplicable, but my engineers are not duplicable. To be frank, I doubt that, because without the data, he would have legions of engineers who would have nothing to do. So you need the data in order to make the most out of it. So we will see how that will work in the future, but there are difficult questions at stake. The third option to deal with data, here come to the Facebook case, is of course to limit the gathering and the processing of personal data. And this is what we have tried to do in the Facebook case along the lines, what are our tasks out there in the digital world? Our task is to keep markets open for new players to ensure fair competition. to protect consumers and, in a way, to protect competitors from the abuse of market power. So I think from my perspective, if data is a key factor, a key parameter for assessing market power, and if data gives you market power, it is only natural that we look at data, how it is gathered and how it is processed. Well, and this is exactly what we have done in the Facebook case. The decision dates from February 2019. In Germany, Facebook has 23 million daily active users. I think that is already an impressive number in itself. 23 million people in Germany are on Facebook every day. 32 million monthly active users, by the way, with a rising tendency. Everyone always said, well, Facebook is declining. It's not, at least not in Germany, it's rising. I think even the young ones who make a lot of use of Facebook and Instagram, when they go to university, they find that it is very difficult to set up a study group via Instagram and just pictures. So this is maybe why they return to Facebook. As a social network, Facebook is not really confronted with real competitors. We looked at that very closely. We asked ourselves, is LinkedIn, is Xing, Snapchat, YouTube, Twitter, are these substitutes for Facebook? In the end, we found no, they are not, because they serve a different purpose. And we sought quite a unique market on which Facebook is active, a market for rich social experience. And if you define such a market, then Facebook has a market share of 80% based on its monthly active users. So from this perspective, we think that Facebook is a dominant company. You also see everything that belongs to dominance in these markets. You see network effects. I just described that, network effects. Every user wants to be on Facebook to meet other users. You have, as we call it, lock-in effects, which means that it is very hard to switch from one provider to another if you find one. Plus, and that is the interesting point for today, Facebook has this superior access to personal data. So how does Facebook get access to all this data? If you want to use data, if you want to use Facebook, you have to agree as the user to a limitless collection of your personal data, both on the network and off the network. So, of course, Facebook collects your data on Facebook. That is not so much of a surprise, and that was not part of our decision because for us it was evident that the user knows that his data is collected here. We saw that the data is collected when you are on affiliate companies of Facebook, like WhatsApp or Instagram. Whenever you see any sign of Facebook on any website, like a share button or a like button, your data is collected. You can be sure that your data is collected without touching the button, without using the button, you are collected. And even if you see nothing of Facebook on any website, your data is collected too through Facebook analytics. So, through these ways, Facebook amasses a huge amount of many different sources, and that is very important because you get a full picture of the personality only if you collect data from different sources. That is what makes your data in the very end so interesting. And in the very end, all this data is combined and is, well, it gets together in order to design a perfect personal user profile. What this has to do with competition law? Well, under German and I think also under European competition law, a dominant company may abuse its dominant position by imposing unfair and illegal business terms. We have a clear jurisprudence on that in Germany. There have been 2 rulings by the Federal Court of Justice who said exactly that. So we concluded from that if Facebook has general terms and conditions as a dominant company that Facebook imposes on the users, that this is not only an infringement of data protection law, but that this is also an infringement of competition law. Why? Because Facebook is dominant. You cannot, as a user, you cannot evade Facebook with its market share of 85%. So it's important also to take notice that not every infringement of data protection rules automatically constitutes a breach of competition law. But if there is a comprehensive and therefore systematic infringement of the GDPR justification rules by a dominant undertaking in a data-driven business, we come to the conclusion that because it is that business, this also infringes competition law. If you look at the Facebook decision, you find round about 300 pages. 100 of them are purely on GDPR issues in the very end. When assessing these data protection issues, we cooperated closely with different data protection authorities. We found that the extensive data collection by Facebook does not only harm consumers losing control of their personal data, but at the same time, competitors who were not able to amass this amount of data were hindered from competing successfully against Facebook, not only in the market that I have just described for rich social experience, but also in other markets closely connected with that market, especially in the online advertising market, because these companies do not have the same access to these kind of markets if they do not have access to this market of rich social experience. We here talk about the leveraging of market power from one market for rich social experience to another market, the online advertising market. So this is why we prohibited certain data collection and combination of data. I think what is new about the Facebook decision is the fact that in the future the user can contradict to the terms and conditions of data. You can say, you can gather my data, but you have to leave it where it is. The data you gather on Facebook remains on Facebook. The data you gather on WhatsApp remains there, and the data on third-party platforms remain there. They shall not be combined if the user contradicts. And if the user contradicts, in the future, he is still allowed, and that is different from the situation today, he is still allowed to use Facebook. So in the very end, the consumer in the future will have a clear choice, and he will have a real choice under which conditions he wants to make use of Facebook. I hope that many other competition agencies look at this case. Maybe not so much with regard to Facebook, but the thing that differentiates this case from many other competition cases is that for the first time we see at least a little bit of what I call a structural internal divestiture of the processes that are happening within Facebook, because they have to keep data separate. Many policymakers out there in the US, Elizabeth Warren and others, they call for divestiture of these huge companies. I think that is very hard to do, especially for a small agency in Bonn. That will not be the easiest task to break up the tech giants in China or in the United States. But we can do something about how these companies work in Europe and in Germany. So this, structural divestiture may be That is the biggest advantage of that decision, and this is maybe something other competition agencies should carefully look at. Facebook has to implement our restrictions within 12 months. At the moment, the clock is stopped, as Facebook has appealed to court and filed for a preliminary injunction. So we hope that we may be able to win this case before court. We will see that in the future. So to conclude, I mentioned it already. Many people ask, what are you doing there? You are a competition agency and you should apply competition law. But even if at the risk that I repeat myself, we know from an economic perspective that data is the key driver for dominance. And that is also written in the law. So we are obliged by law to look at the fact if a company has gathered and processed the data in line with the law. That is a task that is prescribed in the law. And then as a competition agencies, we have two possibilities. We can take an existing parameter to assess data and data protection. That would be GDPR. Or we could start to develop our own assessment of how data should be gathered and assessed. Maybe kind of a, competition law, GDPR, which would be hard to develop. So from my perspective, it's a good idea that we include into our assessment, an existing legal framework, the GDPR. In fact, what else should we do? Thank you very much.
Thank you very much, Mr. Mundt, and thank you all for being here tonight. My name is Catherine Stepp. I'm a reporter for the Wall Street Journal in New York, and I'll be moderating this discussion tonight. We heard from Mr. Mundt about his investigation into Facebook and that case and what you described as the purely data-driven business models that you're looking at in technology companies. We'll definitely come back to that in our discussion, I'm sure of that soon. And we have a panel of competition and data protection authorities here and the Secretary General of the European Commission. So we'll be able to have a wider ranging discussion about how regulators approach companies and how they use data. So I know that we started a bit late. We're going to hear introductory remarks from each of our speakers of about 3 to 5 minutes, and then we will get into a lively debate. And at the end, be able to take some questions from the audience too. So I'd like to introduce our speaker. Our first speaker, we have Giovanni Buttarelli, the European Data Protection Supervisor, joining by video. We have Marie-Laure Denis, the President of the French Data Protection Authority, the CNIL. We have next to her, Martin Selmayr, the Secretary General of the European Commission. We have Elizabeth Denham, the UK Information Commissioner, and to my right, last but not least, we have Ulrich Kelber, the German Federal Commissioner for Data Protection. So, welcome to you all. And let's start out, Giovanni, with your opening remarks.
Good evening, everybody. Good evening, Catherine. Do you hear me? So, I'm so proud to convene such a group of stellar colleagues and speakers, such a crowded audience, thanks to my colleague Ulrich Kelber and the Bavarian Pembret. It's so pity that I cannot be with you, but there are moments in your life where you should respect other kind of rules, which are purely personal. I was recommended to not to postpone a medical treatment, this prevents me to be with you in person. It means that perhaps we will have another option to organize another event soon. Thank you, Professor Mund, for your comments. I would like to pay tribute to your leadership in this area. I can simply fully agree on what you said about the digital power, about the role of digitization in changing the rules of the game. You mentioned also the GAFA group, and perhaps because of new emerging technologies, we should also pay attention to other up to 5, in addition to GAFA, companies who seems to monopolize the world of data. And China, luckily, is not there. And they seem to be the arbiter on what people experience online. Let me spend a few words about GDPR. Last year, 300 meters from where you are, together with members of the EDPS, we celebrated the first anniversary of this important legal instrument. At that time, I reflected that the GDPR was only 12 months old, but already talking and walking, and also showing, let me say, maturity beyond the years. If we go back to 1995, when the first directive had been adopted on data protection, we were a very exclusive club. Now we are 28, still 28, and in addition to Europe, we have a group of 134 countries in the world with the general data protection law. And look for number 135, who will arrive first in between Egypt, Belarus, and Kenya. So GDPR is less exclusive and seems to be something similar to such a popular summer event at the Bavarian Rec. The debate in between regulation and self-regulation is over. The number of countries I counted represents close to 70% of the representatives in the United Nations. There are some still big gaps around the world, particularly US and India. But I'm sure that other colleagues around may testify how relevant today is GDPR in terms of trade agreements, in terms of establishment of internal market around the world. Last year till today, everyone was looking to fines, sanctions, so the efficiency of the data protection enforcement has been properly, but perhaps a little bit excessively linked to the application of fines. One question is GDPR working well? We should say probably yes. We should say that GDPR is not unique, it's not, let's say, special, but it's a model around the world. Perhaps some inconsistencies may be amended in the next future, but we have a robust piece of legislation which is likely to stay for years. My recommendation is to, let's say, move in the second year of implementation to another phase where we not only take care of sanctions, but we also take care of changing the business model, as Professor Moon said. The GDPR provides for certain corrective powers, including, where indispensable, prohibition. So what is essential is that we not only declare that certain processing of personal data are unfair or unlawful, but we need to, let's say, where we do not have a cooperative approach, from the relevant companies. We need to have to pay attention to the exercise of this power, by particularly focusing also on further uses of data which have been collected unlawfully and unfairly. So, question is now the power to stop certain business practices. Question is, then we cannot stay on the laurels. And let me say that now there is another mantra in Europe, the idea that GDPR cannot resist to new technologies, that we need to change GDPR because of big data and artificial intelligence. We have seen important inputs from Germany and France about the ideas to have a better interplay in terms of data protection, consumer protection, and privacy. And we have seen recommendations from Mrs. Merkel to go deeper in terms of values to be applicable to artificial intelligence. But artificial intelligence is a discipline, and therefore, what is essential is that you have and you take your responsibilities for the consequences that come from the use of a machine. I don't see any obstacle from the GDPR to the development of worldwide artificial intelligence. There are two schools of thoughts, and then I conclude. Those thinking that what is essential, like in the Far West, is to arrive first, to put your flag on the land at any cost. While perhaps on artificial intelligence, it would be better that you think timely on a sustainable model to be applied. In a long-term perspective, so a model that can be reliable for many other players and countries in the world.
Thank you very much. So a call for a new phase of GDPR enforcement in its second year of life. Ms. Denny, let's move on to you.
Does it work? Yes, thank you very much. So data-driven businesses represent an increasingly important part of our current economy in the Union and worldwide. Over the past decade, we have seen companies becoming multinational giants with a business model relying on the collection and monetization of users' personal data. So it is necessary to set up a governance framework to fit the digital era. And our discussion today underlines the link between competition, consumer protection, and data protection. So to launch the debate, I would like to focus on two main messages. The first one is that we need a collaborative approach among regulators to address the challenges ahead in a comprehensive manner. The second message is that there is a need to uphold the particular status of personal data in our digital economy. So we have to break silos and build regulatory bridges. And we have heard with the very interesting keynote addressed by Mr. Mundt that data protection considerations are now entering into the assessment of competition regulators. And as a similar logic, competition considerations are now entering into the assessment of DPAs, data protection authorities, with one crucial question. Do market conditions allow individuals to be in full control of their personal data? And this question is not something new for the CNIL. I could mention here the CNIL decision back to 2014 to sanction Google for unlawful processing of personal data by combining, you talked about combining data, by combining data of users of different services without a valid legal basis. Also, in 2016, the CNIL has been heard by the French Competition Authority for its analysis on the conditions for data processing in the online advertising sector. We also had concrete exchanges with the French Competition Authority also on the opening of the market in the energy sector and the modalities for the opening of the historical operator client database, which is called GDF, which was called GDF Suez. And in another, and it's the last example, in another regulatory field, close to our debate today, in 2013, we conducted a joint operation with the Consumer Protection Administration regarding the use of IP tracking for prices purposes. So it's essential to strengthen the cooperation and joint operation on specific issue from a more systematic way and on long-lasting cooperations. And concretely, joint studies and analysis, joint hearings, setting up a forum or network, and promoting staff exchanges, which we have begun to do between the Data Protection Authority and the Competition Authority in France. And also, I think we have to go beyond this cooperation between data protection authorities and competition authorities, involving also other counterparts like cybersecurity agencies and human rights bodies, for example. But my second message is that we need to uphold the particular status of personal data in our digital economy, because the underlying principles of data protection and competition law are clearly distinct. Competition law aims at regulating market conditions, and data protection law relies on the protection of a fundamental right. And this is an essential distinction. The distinction between data protection and competition also stems from EU primary law and also reflects the European humanist model. So personal data are not assets like others. There is a European conception of personal data which is essential to take into account to understand how we envisage data governance and privacy. And I'm not sure if I'm between 3 minutes and 5 minutes, but I better stop now, I think. Thank you.
Thank you very much, making my job easy. Let's hear from Martin Selmayr from the European Commission.
Thank you very much, and thanks for inviting me. I have 3 messages and try to stick to the 3.5 minutes. Number one, I think we only understand properly the importance of data protection for Europe if we look at Europe from the outside world. I think it's interesting when the European Commission negotiates with the current US administration, which doesn't pay attention to all the details of this continent. They always mention 3 policy files that are getting their attention. That is our trade policy, because it has teeth. It is our competition policy, because it has teeth. And since the 25th of May of last year, it is now also data protection. And that is something what I think should make us think. Why is this the case? Trade and competition are exclusive competence of the European Union with a long tradition. Our data protection laws are young and still get this attention. Donald Trump shouts as much about our data protection rules than about our competition rules. So that can make us a bit proud. I think the main reason is that we had the courage in Europe to portray our values, and you mentioned it, the fundamental right of data protection, not to leave this in speeches and directives, but to put it finally, after long experience, into a regulation that has teeth, and that's why it got attention. And I think what is a message that, and I say that notably because Mrs. Schroeter said at the beginning something about the big debate that was taking place in Germany about the data protection regulation. We have to make sure that we don't mess it up, this regulation in Europe. The data protection regulation, the GDPR, has 99 articles. 99. A member state like Germany has made out of this 3,999 national and regional provisions. 3,999. You can count it. And I think every day some more are added to that. That is not what the purpose of the exercise was. So the data protection bureaucracy that Mrs. Schroeter mentioned at the beginning, you can also call it typical German hysteria. We are good at that in Germany. We invent something, we bring it to Brussels, and then we lament how bad this is. We're doing this even with candidates for commission presidents, where we're the only one who are excited about this. And no other country has the same debate about the GDPR and about commission presidents than we have. That is rather interesting. So I think let's go back to the basics. Let's make rules that are simple. And please, Europe has tried that. We should have this in all member states. And I think there are many member states who have done this in an exemplary manner. I hope that also the fantastic Federal Republic of Germany can do that, and that we don't need too many infringement proceedings from the European Commission in the coming years. We will, in 2 weeks' time, publish a communication from the Commission about the GDPR 2 years on. And there's one word in there: please stop the gold plating. And please, Mrs. Schroeter, bring this home to your authorities. So that's message number one. Because otherwise Donald Trump will not take the GDPR seriously as he does at the moment. We have here even people in Washington who say this is a great law, we need this as well here in Washington. So it can be a successful export product. Message number two. Data protection was for many years a very boring policy field. I have to say that here, even in front of all the distinguished data protection experts from national data protection authorities, they all tried to make it interesting, but it never was so interesting in the big companies. Nobody paid really attention in the big companies. And then came the GDPR. Because it introduced concepts that we borrowed deliberately. We in the Commission had a big discussion about that from competition law. You mentioned, Mr. Mund, the portability of data, Article 20. I can tell you, when we discussed this in the Commission, we had half of the people in the Commission who told us that has nothing to do with data protection law. We even added another legal basis because some people said you cannot base data portability provisions on Article 16 of the Treaty of the Functioning of the European Union. Because it is clearly a concept that was exported from competition law and from competitive telecommunications law, from number portability. But it was put in there because you cannot speak about privacy if you don't add to this also choice, the freedom to choose, because otherwise the principle of determining yourself who owns your data is undermined and contravened. And therefore, I think it was a good that we imported that, like the other import from competition law, that is the fines. Yes, we say today it is not about the fines, it's not about the sanctions, but let's be clear. It was the sanction that got us the attention for data protection. It is the fines that at the end made sure that these are laws with teeth, not laws which you can ignore. The fines were the ones that got us the attention, and that's why we have in the compliance departments of the big companies today people who know about the GDPR. That is why the GDPR is known today, and that's why Mr. Mund is here today. Mr. Mund would not have come 10 years ago to a data protection conference in Brussels, and he would not have written 100 pages in the Bundeskartellamtentscheidung about the GDPR. I counted it, it's 10 times more reference to GDPR than to the GWB, which is the German competition law, which is rather remarkable, and I think makes us, who are on the privacy side, of course, very proud. It shows that data protection has become a bit sexy, otherwise Mr. Mund would not be here. My third point and my third message is, I think also now, and that is again, Mr. Mund's presence shows that, competition law learns now also from data protection law. There's a convergence that goes in both directions, and I think this is good because both fields of law have something in common. Both of them are about human dignity and about choice and about freedom. This is what these two fields of law are about. And they're about independence. In both fields, we have very, very independent supervisors, independent authorities that have teeth, and I think the data protection authorities are still developing into the equipment, the resources, and we in the European Commission help on that one. We will make as another main point in our communication in 2 weeks' time, we will say what is the most important thing to make data protection work is to equip independent data protection authorities, not only with independence in law, but also independence when it comes to financial, technical, and human resources. Otherwise, they are toothless tigers. But I think what we see that competition law today takes data protection seriously more than it was ever the case before. I remember the first Google decision of the Commission, when some people said, but is not there also something with privacy in there? And we were very strict at the time and said, no, it has nothing to do with this. This is another field of law. And today, more and more, not only Mr. Mund, but we are doing this as well in the Commission. If you look at the Microsoft LinkedIn murder decision, at the Facebook WhatsApp decision, and the Apple Shazam decision, we have suddenly a convergence. We are importing now concept of data protection into our competition law consideration. Because as Mr. Mund has rightly said, data is power, is market power. It comes into our reflection, our competition law reflection, as an element of quality. If you look at the decision Microsoft LinkedIn, when Microsoft in 2015 notified the Commission of its intention to merge with LinkedIn, then we looked at the market and saw that other professional social networks, such as Xing, with a strong presence in Austria and Germany, offered users a higher degree of privacy protection than LinkedIn. And the Commission's investigations revealed that the degree of privacy protection offered was of key importance for consumers in these countries for their choice, and therefore a key parameter of competition. And we were concerned that as a result of the integration of LinkedIn into Microsoft's software suite, competitors such as Xing, which offered a higher degree of data protection, would be prevented from being installed in and interoperating with Microsoft product. As a result, they could be shut out of the market. Therefore, our decision to allow in the end the merger was only possible after Microsoft committed to address these concerns, and Microsoft committed to ensure that computer manufacturers and distributors would not be required to pre-install LinkedIn on their computers and would be free to pre-install competing professional social networks. So data protection concerns were decisive in the market analysis, in the definition of the remedies. Our interest was to make sure that consumers could still be choose between social networks offering different levels of data protection. The decision of
I have to interrupt, sorry. Maybe we could come back to some of this in the discussion.
I finish here.
Yeah.
Therefore, the decision of Facebook is a decision of Mr. Mund, is a decision, it goes more into detail than we could in our decision, but it shows one important thing. The value decisions, the balancing of interest in the GDPR is used as authoritative standard in competition law, and I think that's how we can proceed. We don't need to develop a separate field of competition data law. We can use and borrow, and that is why I think this convergence is something that will be the running theme of the next 5 years. I'm very sure about that. And thank you for Mr. Mund for being here today and showing that data protection has become sexy.
And you have a very dedicated reader too, apparently. Ms. Denham, let's move on to you.
Well, I'm also really pleased to be here tonight, and I've stepped in to fill in for Andrea, and that's not possible, so I'm going to change my hat. I'm not going to speak from the EDPB perspective, and I don't have any opening remarks because I've been up all night the last 2 nights talking to lawyers about our first big fines under the GDPR. So I will talk about whether or not the GDPR is all about fines as well. But I wanted to say a couple of things, and my colleagues have taken some of my best lines already, which is data protection has become sexy. What's with that? How many people in the audience have been in data protection for more than 20 years? Okay. And 20 years ago, if you were crossing a border and you were talking to a border guard and they said, "What are you doing?" and I'm in data protection, nobody knew what that was. And 2018 was the year that data protection went mainstream, and it went mainstream because of the GDPR, which became dinner time conversation in Europe, in the US, and elsewhere. But also, there's convergence, not just in areas of law, like competition law, consumer protection, and data protection, but there's a massive convergence and discussion about getting data protection right, and a clamor around the world for people to have the kind of rights that EU residents have. And that's why we are seeing convergence of a lot of the concepts in GDPR. We see them in the Brazilian law. We see them being discussed in Japan. Some of us were recently in Japan. Mary-Laure and I having all those discussions. We see my country, where I come from, Canada, looking to modernize their law and looking at the GDPR. But the GDPR is not an EU invention. The GDPR brings the best of laws and traditions and best practices from around the world and puts them into a statute that then emanates out to build the the standards around the world. So I feel really good about the convergence that's happening and the rising of standards and protections, obligations that companies have, and also the expectations that citizens have that they will be protected. And I say that's a clamor, and that's what we're hearing around the world. So convergence internationally is what we see, what we hear. In the UK, so wearing my UK ICO hat, like Marie-Laure, we're very connected with our competition regulator. Don't always agree with them, but we are connected with them. There's an internet advertising inquiry that the CMA in the UK is studying. They're looking at the advertising, they're looking at ad tech, so are we. We've just issued a paper on real-time bidding and the use of data in that process. So we are joined together to look at some of these issues. We know that some of the decisions that we could make in the advertising space could have a negative impact on some of the smaller players in the market. So we have to be aware of perhaps unintended consequences and the kind of tensions that exist on the competition side of the work that we do. So we are joined up. We do have secondments. You stole all of my best lines. We actually do research together. This is really, really important. So those are two of my points. And my third point, if I can remember it, is about fines. So is the GDPR all about the fines? And I've been myth busting for the last year and a half to say GDPR is not all about fines, except it is the way that we have the attention of the CEOs in the boardrooms around the world. It's how we've got the big companies paying attention. However, we are dealing with companies the likes of which we have never seen before. And the fines are not going to be enough for us to really change the business models, which is what the GDPR is really set out to do. Not 183 million pounds for a cybersecurity breach. We need to change the business models, and fines aren't going to do it. I think international regulatory tools and cooperation are the way forward, because otherwise we have 25 data protection regulators, pick a number, and 50 competition regulators that are picking away at the same companies. And we need a different process, and I'll end there.
Thank you very much. And now let's hear lastly from Mr. Kelber.
Yeah, thank you. In the next 12 to 18 months, the decision has to be made which direction digitalization will follow in Europe and for the Europeans in the next 1 or 2 decades. Does Europe just watch while United States and China set the rules? Or is Europe able to enforce its interests and its values? Do we accept our citizens to be tracked and analyzed all around the time, or can we set limits to the way data are collected, monitored, and analyzed? And do we mourn about data protection as blocking innovations? Hear that every day back in Germany, from politics, from companies, from medias. Are we able to show that IT security, data protection, privacies can be made to a unique selling point of European products and services? There's a wide field for the lawmakers, just things like e-privacy. And this is a field for authorities. In different field of politics, like the collaboration between competition authorities, data protection authorities, in the finance sector, the technical authorities, and others, and the collaboration among the data protection authorities to enforce the idea behind that big milestone of the GDPR in practice. And we are now in the 14th month since the real start of the GDPR. And no decision is made about the major, obvious data protection violations by one of the large data-driven companies. So that's one of the reasons why I think that the decision of the Bundeskartellamt was so inspiring, because it has a kind of a fingertip, for example, on the idea is there really a legal base for collecting all that data in every corner of the digital world if you just want to use one single digital service. And this idea is there. It is a concrete, informed, and voluntarily willing in that collection of data has to be made by the data protection authorities. So we have an intense working plan for all our plenary meetings, important work, but we have to deliver the most important choices in this year in 2020.
Thank you very much. And I know that Ms. Denis has to leave early, so I want to ask you about the point that Ms. Denham was just making about fines not being really the whole main point of the GDPR. How do you, as a regulator, change how companies use data? Up until now, we saw some other notices of fines under the GDPR announced this week, but up until now, the biggest GDPR fine was from your office in France.
Yes, thank you very much. But now it is not the biggest fine, even though Elizabeth spoke about an intention of fining. Yes, well, I agree with Elizabeth. Fines are important because I think you have two legs to get compliance. I mean, is to accompany the firms and also the public sector, because we only are talking about private sector, but we also have to make sure that GDPR is well implemented in the public sector. And for example, at the CNIL, last year, we delivered 120 opinions on draft bills or regulatory projects also. So fines are important so to achieve compliance, but we try also to, and the fine was about Google transparency and information which was not well made, and they're appealing also in court, even though they paid the fine. But which is important for us also is to accompany firms and to give tools to them so that they can be compliant. For example, we launched a MOOC a few weeks ago, which had great success, 3 or 4 hours of GDPR comprehensive, I hope, remarks, and we have guides for small firms. Of course, we do not address in the same manner for big firms. And we have seen that GDPR also, well, CNIL is an old data protection authority because she's 41 years old now. But the focus given by the GDPR has brought big awareness among people, among citizens. For example, we have seen that complaints at the CNIL have reached 12,000 complaints in 1 year, more than 40% of increase. And for example, we have had more of 80% of visitors in our website. So I think it is all this variety of awareness, accompanying actors and fines, and also being very active in the diplomatic data, personal data, in Europe, but not only beyond Europe, as Elizabeth Denham said it very well, which I think can make the success of the GDPR and of our values.
And I want to talk more broadly about what kind of sanctions can be effective for changing companies' practices and how they use data. Mr. Mundt, in your keynote, you talked about data portability and also enforcing access to data. And you mentioned that is an issue also for the GDPR. How do you enforce access to data and still comply with the GDPR?
Yeah, that is an excellent question indeed. Hard to find a good answer. Maybe let me start with fines. I mean, we as a competition agency, we have a lot of experience with fining companies. I mean, Mrs. BfDI has imposed billions of euros on Google and others. We take a different perspective on that a little bit, because in these kind of proceedings, abuse proceedings as we call them, we don't impose fines, and personally I don't miss them, because my economists say, and I believe in that, a fine is a price for the company, and for some of these companies I think the fine must be extremely high in order to change things. I personally believe in other things. I believe that if we find an anti-competitive business model, we have to change the business model. I think that is key. So we would have to impose structural remedies that make sure that this kind of behavior is not the future. And here I come to this question of access to data. I mentioned in my speech that we haven't granted access to data yet, although I believe we could do that. There are great many decisions by competition agencies, Mr. Selmayr has mentioned some of them, in which access to data, the combination of data, has played a huge role. Maybe the most prominent one is the Microsoft LinkedIn decision, where this has been pronounced very loudly. But there hasn't been a case, as far as I know so far, where we have really granted access to data in order to give a company the opportunity to compete. And here I must say I see huge problems as I see it today, because I mentioned this also. That would mean in many cases that you would have to grant access to personal data for third parties. And how to do that under GDPR rules. I don't know if this is really something for the time being for a competition agency. Personally, I believe that this is probably something where the legislator needs to step in order to set up clear rules where access to data must be granted and where not. Think of the piloted car in the future. I think that deserves clear rules by the legislator, how this is going to be set up. This is nothing that can be done by competition agencies. You cannot leave it there. And again, to grant access to data, to the data trove of these one of these huge companies, that may be a huge question in the future, but it's for the future, and I think we're not there yet from my perspective. Maybe it is a question also how to gain some experience, for example, with the GDPR and see how it works in these kind of cases.
This is something one of our data protection authorities want to weigh in on. Mr. Buttarelli.
Yes, I hear you.
Hi, would you like to weigh in on what Mr. Mundt was just discussing about sanctions for competition cases and concerns with the GDPR?
A lot of good comments, and not only from Andreas Mundt. He's right in focusing on clarity for access to data. He mentioned also the idea for creative solutions in his previous intervention with regard to the use of data in a context rather than in other tree. And here we have an interesting interlink in between competition and data protection because of the newly designed right to object, and not only for legitimate purposes, which may be relevant in case of an Instagram, a WhatsApp, Facebook, or someone else, specific users not interested because of the new privacy policies they disseminated in May last year to see his or her own data used for many other purposes. I've heard other comments, not only from Andreas Mundt, about the need to show our thieves sanctions and fines are an important part of the strong enforcement. And we are speaking here about administrative fines. Please do not forget that we have other kinds of sanctions where relevant at national level, according to certain very well-known principles. And this display also the need for a little bit or more connection with the national judiciary, even in terms of cooperation between DPAs and the judiciary, but also in terms of possible trainings. For fines, we have a lot of principles in terms of scalability, so that you may clearly distinguish cases where the data controller is proactive against others where the infraction is so severe. And severity is to be displayed also with regard to data breach notifications and breaches in general terms, and also, as said, in terms of cyber security. What I said in my previous contribution was related to something else, to reinforce a proper implementation of the GDPR. Let me speak for a second as former Secretary General of a national DPA for 12 years. And here, what I've seen is that some companies, of course, takes care of the reputational damage. Or because of the severity of the fine, they don't want to pay, they appeal, so they do their best to circumvent the enforcement action by the DPA. But where I saw the biggest resistance to an action by a national DPA was in resisting, appealing, and contesting the blocking of data, the freezing of data. Some companies, not only those of the GAFA group, may continue to consider, notwithstanding the severity of the GDPR fines, a fine as a budget line. So in public, they appear as desperate. They have to pay a lot of money. But what they consider as essential is that they can keep the data. They can continue to use the data whose use has been declared unlawful or unfair. So my recommendation to now, once the 20 plus other main investigations still pending in a few countries will be completed, is to consider at the decision-making point, in addition to the proper fines, also this decision about the use of data. The citizens, even if they do not object individually one by one, have a right to see their data destroyed or anonymized or pseudo-anonymized, unless there are some other good reasons to keep them.
Thank you. Ms. Denham, you said that the GDPR is not all about fines, but you just issued notices of what would be the two highest GDPR fines to date against Marriott and British Airways. So what are effective ways to change companies' data practices? And what tools do you still need to do that?
Following from what Giovanni said, there are other tools that we have available to us that are extremely effective, and those are stop processing orders. Those are orders to delete data that was improperly collected. And in the UK, we recently ordered the Treasury to delete 5 million voice prints that had been collected in contravention of the GDPR. So again, that's a big lesson for central government, that they implemented a system that's not in compliance with the law, and they are ordered to delete the images. So again, that's a powerful message. And I think as regulators, the most important work that we can do is to take those 99 articles of the GDPR and actually translate them into real cases and real stories and real narratives that people understand. So you take one case to delete all of those biometric voice prints, and now you have public bodies around the UK that are talking about the requirement to collect that kind of sensitive data properly. But you need the stories. The biggest story of the year last year was Cambridge Analytica and Facebook. And people weren't always, I know everybody in this audience knows the detail of the story, but most of the public and journalists didn't necessarily know the details of it, but they knew that something went badly wrong that impacted our democratic rights. And there's a narrative there. There's a company that was doing wrong, that is now in administration, that has been that has been put out of business. We have their servers as we crunch through all of that data. But you need real cases. You need the real fines to be able to get people to pay attention to that. So you need all of those tools. The other thing that we need as data protection authorities, besides the real cases and the real actions, are the real powers to be able to do our work properly. And so we have to look to our domestic legislators to give us the real power to carry out modern digital investigations. And that was something that we were able to ask our parliament for in the middle of Cambridge Analytica and Facebook. Again, a real case where it took us 3 days to get a warrant, and we had to give notice to companies, no surprise warrants. We didn't have the power to be able to reach into the cloud to get access to data. We couldn't compel individuals to come and testify before us. These are all of the powers that we need. We also have the power to prosecute companies and individuals, but we need these kind of powers to do our work. Because if we can't get in the door, if we can't do a no-notice inspection, if we don't have the audit powers, if we can't prosecute, then we can't do our work. So I think it's really important to look at independent authorities, but independent authorities with real power. And I think sometimes we look at competition authorities and say, they've got all those powers. We want what they have.
Well, how could competition and data protection authorities do more to work together? How could they do joint investigations? I mean, you mentioned already staff secondment exists. What else could you imagine?
I mean, the first step would be that we learn from each other. I mean, joint investigations is not an easy task. We already see that among competition agencies. We have a very sophisticated network of competition agencies within Europe, the European competition networks. We apply mostly European competition law. We cooperate. We have joint working groups. We do dawn raids together. We can exchange confidential information among each other, but that is highly institutionalized and highly formalized. All this would be lacking between competition agencies on the one side and data protection agencies on the other side. So here I see much room for cooperation, which is also very helpful. That might be informal. This is exactly what we did in the Facebook case, where we cooperated a lot with German data protection agencies also in order to make sure that we were on the right track. I mean, this was not our home turf, so it was very helpful to have someone beside us from whom we can learn. But this is an excellent start, I would say, because also among competition agencies, there is a lot of informal cooperation, and it takes us very far, you know. So I would very much like to see do us more in this respect. Also now with European competition between European and other national competition agencies. In Ireland, for example, Ireland plays a huge role in this respect for the time being. And I think here we need to see more. That would be very helpful.
I don't see a legal base for a joint investigation of competition authorities and data protection authorities, but no one is blocking us for exchanging informations, for exchanging about strategies. And our work as data protection authority is about protecting privacy of individuals. But we know that this work has an impact on the integrity of society. And we do know that data protection laws doesn't have an impact on things like monopolies and of prohibiting monopolies, of transforming the business cases, but sometimes we have to see the perspective of that work, for example, in the questions of interoperability of services, the question of opening these data repositories of the large companies to competitors. There are risks for data protection in such steps, and to see how we can implement such tools in a safe way for the privacy question, to form the digital market in a way which is compatible with all the European values, the European ideas of how companies should work in that way, the interests of European companies in their competitiveness with the Chinese, the American, and maybe some other world region companies. So, and this is the idea of that authority, is to be in a close contact for shaping the digital future of Europe.
Okay. We did start late, but I'd like to make sure we have a few minutes for audience questions, if there are any. So please raise your hand. There's one in the back that I saw that went up first. Here in the back right, and then there's one on the left. Just there in the back, this man raising his hand.
Hello. Hi, I'm Gerben. I have a background more in software development and in politics. And I have a question mostly to Mr. Andreas Mund. I totally agree with you that the most important thing to do, or one of the most important things, is to fight the anti-competitive business models of these companies. And I wonder if you have considered to also really look into the question of interoperability that was just mentioned, and interconnectivity. Because with my engineer's view on these things, I look at previous internet technologies like the web or email, and I'm like, well, if one person uses Gmail, even though it is a very dominant company, Google, the people they communicate with, they don't have to use a Google product, they can use something else. There's multiple email providers, and people can choose one, and they can still communicate. Whereas Facebook has, by its design, chosen to lock people into its network. Well, of course, you have the network effect, but the network could comprise many companies that interoperate. I wonder if, from a competition perspective, you would consider prohibiting, perhaps, the network lock-in that is created by not interoperating your technology with other providers. Thanks.
Yeah, we have considered it, but we haven't enforced it. We haven't had a case in this sense. There's no specific reason for that. Maybe we just haven't found the right case. But as someone who is in competition law, you think of an aspect that might not come across your mind immediately, but complete interoperability also means that you might have less competition between companies, because if everything is interoperable among every company, it might lack the possibility to be different and to develop differentiated parameters for your own service. I just want to leave that here. That is something you think about. I think interoperability, I mention it as one of the three options by which you can do more for competition. Interoperability is one of these options. We see a lot of this, by the way, in the area of telecommunication. But that is, of course, something that mainly the telecom regulator is taking care of, and I think it's very well situated. It's very, very well allocated there. But it might be something that we want to look at as competition agency also, if there is a case that comes across our mind. But again, we have that in mind, that interoperability from a competition point of view might also have some disadvantage. So you have to look very careful at a specific case, how you want to act in this respect. But it is something, of course, that might play a role. And again, we find it in GDPR, Article 20, so the root is there.
Thank you. There's another question here in the back left. I'm sorry, could you, there was actually somebody else behind you, and I think the microphone went to him first.
It's quick. Jakob Greiner, Deutsche Telekom. Also a question to Mr. Mund. There are some voices in Brussels that say this Kartellamt decision is something purely national, and it cannot really be transferred one-to-one to European competition law. Could you maybe give us your view on whether this could be something for some future reform of EU competition law?
To be frank, I don't think we need a reform of European competition law in order to deal with such a case. We based our case, no, I've started differently. Usually we apply European competition law. In this case, we handled it differently. We applied German competition law, but not because we or I believe that we cannot do this case under European competition law. We did it with German competition law because we have some jurisprudence by the federal Supreme Court. The jurisprudence is called Pechstein and VBL Gegenwart, very German, has nothing to do with Facebook. But there the federal Supreme Court has said that if a dominant company implies illegal terms and conditions on a contracting partner, this might harm competition law. So this is what we have, and this is why, well, since we have this favorite or this jurisprudence that might be in favor of our case, we thought, and we do not have it at the level of the European courts. We founded it on German law, but personally I'm deeply convinced, I mean, German law and European law are not different, in fact, not very much different. Personally, I believe you can also handle this case under European competition law.
I'd like to hear if the European Commission has any response to that.
Well, I think the Microsoft LinkedIn case shows that we can insert the considerations of the GDPR, of data protection, into competition law. And I agree with Mr. Mund. I see nothing which will prevent that. The GDPR comes from the Charter of Fundamental Rights, which is the supreme law in the European Union, and which has to inspire the application of every piece of law, including competition law. Therefore, the choices that are made there about individual freedom, about the right of the person to access data, to delete data, and not to have data misused, I think also will play a role in competition law. We are not actively looking for this case, because that's not the role of independent competition authorities, like it is not the role of Mr. Mund, and he has not done that. But I see more and more that these data considerations come into our competition law consideration. And if you read the study that was commissioned by Commissioner Vestager and was published in spring this year about the link between data and market power, you see this is something that is the next frontier of competition law in the next 5 years.
Thank you. I think we have time for maybe one more question.
Is it my turn now?
You have the mic now, yes.
Yeah, my name is Alexandra Geese. I'm newly elected MEP from Bonn, as two of the people on the panel. I was wondering to hear your view on a European supervisory authority for digital services and companies. Have you ever considered that? Would you think that might be useful?
I think, Ms. Denham, would you maybe like to respond to that? I know you've talked about that before.
There are so many debates and proposals going on, as you know, around the world to have one super regulator for digital, one regulator for dealing with all online harms, everything from cyberbullying to anti-competitive behavior to data protection. So anything digital should go somewhere and be centralized. So we've heard a proposal like that in the UK. There's a white paper that's looking at online harms and having a new regulator for content. So we've seen that in Australia where they've moved forward with that. There's, again, moves in Canada, discussions in the US about new forms of content moderation and regulation. I think you can't have one regulator for digital because everyone does digital. So how does that work? But I think what we do need is we need a rational approach to dealing with these big companies. Because if you have a company like Facebook or Google or Amazon that is visited by 15 different regulators that are asking similar questions from an accountability or a data governance perspective, that's not going to work either. So I think we need some coordination. We need to figure out which regulator's on first for whatever the prime issue is. We also need better convergence and collaboration, both in law and I think in informal cooperation. In the UK, we have a board that is the CEO for the Competition Authority, for the media telecommunications regulator, and for myself. So we work together at that level, our officials work together, we know what's going on, I think that's really important. But putting a new single regulator in charge of the internet, I think that's an idea whose time has passed. But the public wants it, right? What is the single super regulator?
Mr. Mund, you look like you want to come in also.
Just very quickly, I mean, we do not have one regulator for the offline world either. I firmly believe that we have kind of an endemic under-regulation in the internet and in the digital economy. Mrs. Vestager put it to the point when she said, well, you can do things in the internet for which normally you get arrested in the offline world within 30 minutes. And I think she's completely right with that. And what we have not achieved so far, that we have implemented the rules that we have implemented in the offline world, not only from an economic perspective, but from the perspective, what are our values and how do we want to live together as a society. We haven't arrived at implementing these rules into the online world. And I think this is our joint task. This is a key task of the regulator. But this is also a task for the legislator in order to enable us to do this quickly, swiftly, and efficiently. But again, we have to do our jobs. Every single agency there is out there has to do the job. And if our toolbox is not sufficient, it has to be enlarged by the legislator. And I think this is a joint task. But I'm deeply convinced that one regulator will certainly not do it.
Catherine,
Other speakers want to come in. Yes, Giovanni.
With the footnote.
Yes, please.
I think both Andrea and Ellen were absolutely right. I would like to simply share with you the results of an initiative we launched 2 years ago, the Digital Clearinghouse. And of course, with the contribution of many national experts and authorities, even in terms of consumer protection. The idea that an intervention on governance may make the difference is to be respected, but perhaps is not on the table for the short term, I guess. It's something to be analyzed in the longer term. What is needed for one single argument and reason, because the same regulator will continue to apply several fragmented provisions which are not only relevant for the three areas I mentioned, but also in the area of telecommunications, for instance. The recent debate on online manipulation and fake news showed the important role of certain committees established to ensure the fairness of certain elections. And last but not least, there are other minor authorities competent for the so-called audiovisual area. So let's go for a step-by-step approach where, as Moon said, we should go for informal cooperation, sharing of experiences, have a unique approach with a view to speak as much as possible, regardless of the legal instrument you use, an EU vision which is essential. Cambridge Analytica has clearly showed that we're not only dealing now with the protection of personal rights, it's something related also to democracy, to the integrity of the European Union. And therefore, the synchronization, the cooperation, the coordination will remain key, even if we will not go immediately for joint investigations or stricter actions together.
Thank you. Do any of our other speakers want to come in very briefly on this last point? Yes.
I would say, first of all, if a newly elected member of the European Parliament brings in the idea of a single regulator, we have first of all to acknowledge there seems to be an issue out there that she heard in the election campaign. And I think we have to respond to that. I think one response is not centralization, but that all these regulators who are out there should act like one. We don't need a single regulator, but we need all these regulators horizontally and vertically to behave like one. And I think that is a bit the attempt, what the national data protection authorities trying to do in their meeting today in the European Data Protection Board, to act like one, to avoid divergent decisions, to come together, share knowledge, but also to stay local regulators that are fast and can interact directly with companies and citizens on the ground. I think we need to have the same vertically, horizontally with the competition authorities and telecom authorities, because we don't need, as you said earlier, 15 authorities who go for the same behavior after the same company or the same citizens, but we need that the same behavior is addressed from all different angles in one coherent way. So what we look for is convergence, coherence, swiftness and coordination in a way that at the end of the day for the citizen who wants his fundamental rights to be protected, this looks like one regulatory decision based on the decision of the legislator. If this works, and that is our task to make this work, then we don't need centralization.
They want to see an action figure.
Exactly. Sure.
Thank you very much. Well, we've come to the end of our time. We heard a lot about the case in Germany, the Bundeskartellamt case with Facebook. We heard about the effectiveness of GDPR and fines to actually change companies' behavior potentially. And there are still some questions left for the future, such as how competition and data protection authorities could work more together. And I think that there will be time to talk about that over the reception in the garden and outside. But first we have some really short closing remarks from the Assistant European Data Protection Supervisor, Wojciech.
I think we actually had already the summary of the discussion. So the words like convergence, like regulators with teeth, but at the same time, the whole toolbox will stay in our mind. So let me just thank the organizers, thank the Bavarian representation for having us here, and to invite you to the second unofficial part of this meeting. Thank you very much. We are staying in the discussion.